Hi, good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today's guest is a brand new instructor here at Trias College, and she brings a wealth of experience as a licensed paralegal, currently working for Hyundai there. And Sahana, thank you so much for joining us. And perhaps you can start by telling us, what drew you into law in the first place, and a little bit about what you've been doing since starting your practice.
Yeah, for sure. Well, thank you for having me first. But I actually did criminology as my undergrad, and then following that, I did my master's in criminal justice. To be honest, I didn't know if I can commit to a full law degree as yourself, but I guess it started off as a dipping my toes in the water and gave the paralegal program a try. And I didn't realize how much vast opportunities I had or the different scopes of area I can get into. And one after the other. At first, I was in private practice for a bit, and then I switched to um, the corporate side, I guess. And I was working at Kia Canada for a bit. There, I primarily practiced, I did manufacturing liability litigation. And the auto industry kind of was always close. I've always worked with cars, so it kind of came hand in hand. And then following that, I moved over to my sister company right now, where I'm working at Hyundai Capital as a corporate paralegal. It's more regulatory, administrative stuff with keeping, I guess, the company operating in different provinces. But I also have the litigation side, and it's more so vicarious liability. When you have third-party vehicles getting into car accidents and whatnot, how you go about them, how you deal with that. So that's a general scope of what I do.
Perfect. So let's kind of backtrack and go through everything there. So you were interested in criminology and criminal justice, and often I think when I go back to law school, a lot of people, because I had the opposite. I wasn't really specializing in criminal law, and then here I am doing mostly criminal law work. But I mean, in terms of what you were studying to what you got into after completing your licensing, was there an interest in criminal law, or what kind of led you from there to kind of the path that you're on today?
Well, initially, when I was doing criminology and criminal justice, it was more so, um, I guess, textbook stuff. I was like, oh, this is intriguing. This is nice. And we all have the false idea that it's like suits, you know. But moving on from that, I actually, when I did my placement, I got in the private practice firm that I was in. I enjoyed the work for a bit, for a year, and it was WSIB mainly. And I think that kind of teetered my career a different path. If I don't know, maybe if I ended up in a different spot, if that would have changed my career path. But the placement is where I started, and from that opportunity to one to another. And there is where I got my most of my small claims experience and my litigation, because I got to go to a lot of tribunals and whatnot. And that's what gave me the opportunity to step into Kia, because I had the experience. So I guess it was a path that I didn't really choose, but kind of happened.
Now, maybe you could compare working in private practice versus what you're doing now. I think, again, a lot of students, I mean, especially as you know, most of the students here have very little experience with or maybe practicing law or working in a legal field, and whatever drew their interest. And I'm sure you'll find out more about them tonight and throughout the next few months while you're teaching them. But um, often, you hear about private practice and working as like an associate or a
Mhm.
paralegal at a firm like you had in that first bit of experience compared to now working, whether it was Kia or Hyundai. What do you find is different between those two or three experiences, and what can you share for those who might be thinking, hey, maybe I didn't really think about that I could go and work at a company as a
Mhm.
corporate paralegal? What does that entail?
Uh, to be honest, when I made the jump, I actually didn't know that I would prefer this over that. Initially, when I was at the firm, I think your scope is limited. You almost focus in on something, and you're pretty much routine to know what you're doing, um, and you hone that skill really well. But I was also new to the field, and I wanted a little bit more experience. I wanted to jump around and see what I would like. So when I moved to the corporate side, I realized that the teams were a lot smaller. They were more, if you're in a firm, you're usually working with a lot of people. There's a lot of people specializing in various parts of even one sector of the law. So you get almost a very niche um, role in that company. While when you're working in a corporate sector, you get a whole vast, you get a lot more experience with a lot less people. So you get to experience every aspect of that law. I think that's what it was. And I got to, from writing memos to the basics to going into court, I got to do it all from the beginning to the end. So I wasn't missing a component and it gave me more hands-on experience. So that's why I personally prefer corporate law over private sector, I guess.
So you mentioned vicarious liability. So what are the kinds someone were to ask you, I know obviously as a practitioner and there's no 2 days that are ever really alike, but what are the kinds of things that you work on? How do you prepare for everything? And if if someone were to ask you, maybe I'll ask you exactly this, then what's a day in the life of Sahana there at Hyundai? What can you share with us?
Um, to be honest, a lot of claims, yes, but it's more so because vicarious liability, for those of us who don't know, for example, if you were to lease a vehicle from Hyundai or one of our car companies, we're part owner and you're part owner. So we share kind of the responsibility that comes like out of an accident, and we have to kind of explain our role in the accident. And more often than not, the company is not responsible because we obviously weren't in the vehicle driving it. But when the claim comes out, it gets addressed towards the person that was driving, but also the the company, because we could have a role as if we were selling a vehicle that had manufacturing defects in it, or we didn't choose our lesser in the correct capacity. Usually some of the items that they list is, the person's driving record wasn't verified, or that we didn't, we chose a person who's had numerous accidents that we should have known better. Again, these are not things that we look into when we're selling a vehicle because the job is very different from what they're claiming from us. So it comes down to contract law basically, and we have a contract that we sign with the lessee, the person driving the vehicle or borrowing it from us, and we take down the facts of the case and explain um, this is what our role was. This is what the driver's liability insurance covers. This is what they are expected to hold when you're purchasing a vehicle from us or borrowing a vehicle from us. Sorry, and how they should go about it. And usually we get named out of the suit about halfway through because they realize, oh yeah, they weren't driving the vehicle. They're not responsible. They just had to make sure that the insured had appropriate insurance to cover any such damages. But there are times where our liability will get engaged in case if we let it slip and um, the insured didn't have insurance and we didn't notice that, that would be our fault because we let you borrow our vehicle, but then we dropped the ball and it would be negligence on our part. Or if your insurance fails to after it expires after a certain period of time, it's also my responsibility to make sure that you still have it because it's my car that you're driving. So it's kind of a two-person, I guess a two-party role on our side. Um, that's kind of the vicarious liability portion of it. But we also have small claims where people, especially during COVID, actually, we've had a lot of claims come through because people default in payments. And when our collections team starts to send out notices and they start to avoid it, there's obviously a point where we tow the vehicle off your lot or we send it to the credit bureau and it starts to affect their life. And then they claim that we're either harassing them or that we've stepped too far. And there's obviously guidelines in place for us to make sure that we behave in a certain manner, even if we are collecting. There's rules, laws. We can't just do as we wish just because it's our car. So we have to prove that we've met those. And those are some of the claims that come through. There's apart from payment, there's people who feel like if they signed a contract, one of our lease contracts, and they feel like they were wronged because they thought they were getting a better deal or something like that. They might come after us. So those are types of small claims that I would deal with. And apart from that, there's a regulatory portion of it as well, annual returns for us to operate our dealerships in the various provinces. And so not only Ontario, but all through Canada, we have dealerships with different requirements for each province as well. Even though we're all under one country, Yukon may ask me for, 3 different things than this than Ontario. So I kind of have to maintain that. And There's also the minute bookkeeping and whatnot with director changes. Corporations usually have a board of directors, but uh, when you're a foreign company like us, Korean company that's in Canada, the board of directors are usually also Korean, coming in from expatriates from that country. So they, after a couple years, they leave, and that means there's always a change, and that means I have to update the bylaws and whatnot. So that's usually how my day goes. There's the various there's various things I do in between, but main components would be those.
So going back to, I guess, the liability there. What about if it's on the other end? Let's say someone gets rear end, someone with a Hyundai vehicle gets rear-ended,
Mhm.
and obviously there's going to be damage to the vehicle that you're going to look to recover. So do you have to kind of go after other drivers on behalf of your lessee? I think is the word.
Yeah, so
Yeah.
actually it works out really well for us in that front too, because the lessee's insurance usually will protect us because it kind of goes, they were responsible. So that's why we share the responsibility. It doesn't work out in favor for the lessee, I understand, because when it comes down to an issue, we do throw our hands up and go, well, we weren't driving, but we're also letting you borrow our vehicle at a lower price or a discounted price because you're leasing it, not buying it. And we're going to take care of some of the damages and costs that come along with it. But in regards to our vehicle getting damaged, you're responsible when you return it to have it in the condition that we gave it to you. Obviously, minor scratches and things like that is not covered. It's covered, but anything major, would your insurance should cover it. And if you didn't have it or whatnot, the person borrowing the car, the lessee would be the person that is responsible for the damages. And then we would have to go after them. But usually it never gets to that. Usually the insurance covers it and gets inside, and they're like, okay, we got this.
Yeah, I mean, I think it's interesting there that there's so much in leasing a vehicle versus purchasing, right? That you don't
Yeah.
realize it. Now, are there anything? I mean, let's say if you buy a vehicle and you go through, you mentioned COVID and certainly economic times there where people were losing jobs and maybe they're not able to pay back a loan from the bank or whatever that they got to cover it for the purchase. But is there any differences in terms of if it's leased from you? Do you have any mechanisms you can do? Rather than essentially wait for them to default and then pursue an action in small claims court. Like, are you able to kind of like repossess the vehicle as a result of it being leased versus obviously the bank can't do that if it's a debt that was used to purchase the vehicle?
Yeah, so we do have the ability to repossess vehicles, and that's usually following which is where I get the claim of harassment because we've stepped on your property, we've taken your vehicle away from you, things like that. But I think that again, it goes down to the essence of our contract where it lists that these are the requirements that have to be met. And when you don't, we do have the ability to do this. And in extenuating circumstances like COVID, we did give the opportunity for people, like we gave them delayed payment opportunities. We've given them payment structure like different options to, I guess, rearrange their life in a way that they can meet the payments, or break it down for you, extend it, not. But there's only a certain point we can do it to. So I think it was after a 3-month period, if you are not able to keep up with it, we do have to do something because it's coming out of our pockets at that point, or it's a loss. So it is a little bit different because I think banks don't work, um, I guess, in a more, because it's our vehicle, and if you're borrowing the money from us, we have more leeway. But if you're borrowing it from Scotiabank and you're asking me to do something about it, I can't really do anything. I gave you the vehicle, but you borrowed the money from Scotia. So they have a little bit of say in it as well. So there's like a triangle of parts that go to it, and the parties involved have to kind of negotiate and agree to it. But more often than not, the banks are a little bit more tougher than us.
So maybe let's look at it from if it does go through to small claims, whether it's the vehicle got damaged upon return and they're like, well,
Mm-hmm.
whatever, I'm not paying for it. Here's your car back, and I've taken the 36 months or whatever it is, or I don't know, 5 years, however long they leased it for, and maybe there's an issue there, or like you said, they just can't make the payments. So you go to small claims court to essentially get the outstanding amount. What's that process like? I know it's you can essentially talk. There's a whole courses or two
I
courses
know.
actually on small claims, but maybe you can kind of explain here. I know it'll probably tie into the intro to legal course that you're going to be teaching, but
Yeah.
just what the process is from the start when someone comes to you with, or Honda in your case says, we're going to go after this lessee, to collections or enforcement of a decision.
Um, well, there's a couple of things that go into play first before. I feel like if I was working for myself, it would be a lot different because you'd be like, okay, you know what, I can go to court. This is what it is. But technically, with the business's interests at hand, it's almost like, is my time worth it? Would I be valued at, like, if I was doing this, this, and this in an hour, I think I would be making the business a lot more money than if I was to go to court for $200. So it kind of, you have to weigh your cost benefit here. But if it gets down to my department, I guess they usually have tried alternative methods by then, and I do the basics where I ask for the case notes, who our initial department that reached out to them was, what the problem was, identify, and ideally we try to set up a time and talk to the lessee and say, you know what, and um, we get a notice period before people even file small claims courts. People actually send letters to us from their counsel or for themselves saying that this is what I want, this is what I'm doing. If not, I'm going to file, or I'm not going to pay and whatnot. And so that's the point where I reach out to the customer themselves and I'm like, this is what it is. This is why you're going to be responsible for it. I try to negotiate a payment, maybe a reduction, whatnot. And if it still doesn't work, that's when I claim the full amount. We start drafting a small claims court um, uh, a claim, and I would file it. And usually, at the alternative dispute resolution options, we have mediation is usually where it settles. I don't have to often go to court, but there are times where I do. But at that time, we bring all other than just me going and saying this is what I want. I also have to negotiate and value if it's worth going to trial for. Is it really worth my efforts to do this? So at that point, I bring forth, you know what, this is what we want, but we're willing to do this. We'll remove this off your credit bureau and give them alternatives, and a gift card to your next purchase or whatever it is. And at that point, they do drop the suit. We close the matter. But on the terms that it does go to trial, then I have to prep, and usually it involves because I work for the company and I'm also a legal rep. I can't be both parties, so I have to bring somebody else from a department with me to explain as if they were my client. So that's the different thing that a lot of people don't understand. So when I show up, they know that I'm also working for Hyundai, so they think it's like some sort of internal plan that we have against the other side, and it turns a little heated. But as soon as we explain our situation, explain that the contract is almost like our Bible, and it outlines almost any issue and anything that we could need to get covered. And because we have that, it's a lot easier because you can't really negotiate it because the lessee willingly signed off um, on the terms. It's not like we told them, this was something brand new to them, and they obviously had 48 months usually is the least period that they take upon. 48 months you didn't have a problem with the terms. You can't have a problem now that you're done using the vehicle. That's usually what happens. And it gets rectified usually at the end by court. And at that point, they've also wasted time going to court. They've wasted their money. They've wasted resources hiring a lawyer and whatnot. So sometimes it's better off in the beginning to to sort it out. But we do go the full extent if need be.
You mentioned ADR and mediation, and certainly in small claims court, they have settlement conferences. Maybe you can explain a little bit about how that works for the students here, especially who may not know how. No, one of the things, actually, I'm actually teaching alternative dispute resolution in the morning. I think you
Oh,
popped
nice.
in last week.
Yes.
And it is interesting because when I went to law school, it was all about trial advocacy and how to be very effective. But I mean, a lot of the matters, I mean, overwhelmingly, as you can probably attest to, don't go to trial. So, what are some characteristics and skills and preparation needed for trying to get that resolved? at a mediation or through settlement conference and small claims court?
I think when I stepped into your last class, the BATNA that you were going through, alternative, is, I think we often forget that when we go to court, neither party is going to get everything they want. It's almost like a negotiation, and you have to come in with your best foot forward, yes, but also accept that you're going to have to compromise, and you have to realize, what are you willing to give up? And that's kind of what we do with the business as well. What am I willing to, sorry, there's just a question that popped up. It depends on the situation. Usually, if it's sorry, Martina. It depends on the situation. So sometimes, if I've already reached the court situation, then it's a mediator it's usually a court mandated mediator that will do the mediation. But if it's me calling at the initial, the letter that they're sending out, in regards to the issue, I usually mediate, and I put the team, one of our collections member or our customer experience members that kind of represents the business, and they already know where our business stands with it. They're at their own position, and the customer obviously is on the other end. And I kind of have to play an impartial role. And I explain that although I work for them, I don't have an interest, the money is not mine. I have no personal vested interest in this. I'm here to point out what both parties have and what both parties are trying to bring forth. And in regards to the court situation, when we do go there, we have, JP and I just broke out into a room. That's usually kind of how it's been happening because it's been online. So we hear both sides, and then the judge will take us kind of separately to discuss, and then come back, meet with us separately as well, and give us the other side, what she thinks she might suggest, she'll actually sometimes, yeah, she or he will actually sometimes suggest what she would do in our position. And that's usually where the mediator is trying to be like, this is where I think it would be impartial or fair to both parties if you guys ended up here. And gives us the option. Obviously, at the end of the day, the business still can choose, and they give me a limit, or they give me a maximum I can go to settle this matter, and then that's kind of where it ends up.
I see there's a follow-up about appointing the mediator. I mean, maybe you could explain how the settlement conference, for example, at small claims court, how that gets selected. Or
so when you're filling out a small claims court, if you haven't taken the course, usually when you're filling out your form, there's an option at the bottom that says if you are willing to opt in for mediation. Sometimes it's mandatory, sometimes you get the option, depends on your matters. But the matters that do come to us, we always opt for mediation because it's the less expensive route for us. We would prefer not to go to trial, spend hours of my own time. But the client appoints the court appoints the mediator, and they send us notices, and they kind of work out a time that suits the both of us, and we move forward from there.
now you mentioned Zoom and breakout rooms, and I think obviously the very foundation of court and tribunals and everything has changed because of COVID. What has that been like in the last, I mean, it's not even more than a year and a half now, but what have you noticed? What you've liked? What should students kind of understand what they're getting into now? With a lot of this might still be around, past COVID, that we're going to keep a lot of the virtual things. And what advice do you have for them with that?
I do think the virtual thing is around for a while. It's going to be around for a while now. I think it might be the new norm. In the initial stages, it was a lot of tweaking. We didn't get to have the breakout rooms. It's a little bit more like, you need to sign off and sign in. There was a little bit of tweaking that needed to happen, and which made it a little bit harder. But I think there's a level of respect when you're in person that is lacking when you're online. Because I've noticed when you're even in your court, when you're in court or you're in mediation in person, when another person's talking, no matter how heated you are, there's a level of respect where you don't talk over them. But when you're online, it's almost like there's chaos sometimes where everybody's arguing, everybody wants to say something, and there's overlap. Those things kind of make it harder. And there's also the technical portion. Like some of our lessees are older lessees, or they're not used to using I guess computers to the extent that we are on a regular basis, or they're not adapting as quickly. And sometimes when the judge is asking you to do something and you can't do it, it almost aggravates them, and kind of, I guess it creates this an environment that's not comfortable for them. So it's really hard for a client to be like, you know what, I'm not going to back down now. It almost creates a negative environment, which makes it harder to mediate something when you're trying to get everybody on a calm tone platform. So there's things like that. But I do think it's also very convenient, because I feel like there's less travel, you're not wasting as many resources, you're able to do it online. Um, I'm not printing out and taking everything with me to court. I have everything, there's things like that. That's obviously a perk. So um, things are getting smoother as you get more and more comfortable with the process, though.
Now, before I was asking you about preparing for ADR and in settlement conferences and like that, is there anything different? And certainly we can also look at it from preparing for trial by Zoom versus trial in person. Anything that students should, especially over the year and the program that they're going to get into, that they should really take away and prepare any differently from, because it's online versus in person? Or do you find that you're doing the same thing, it's just maybe more technically knowing how to share your screen with the
Yeah,
evidence and stuff like that?
that's definitely more so it. I still prepare as if I was to go in, because at the end of the day, if I didn't have my computer and I got pushed over, or the court had enough time to ask me to come in, I'm gonna have to show up. I should still be prepared the same way. There isn't like a shortcut because I'm available on. I can just pull something up later, um, and I also feel like I personally like it when I have hard materials in front of my hand. So there's certain documents it's hard for me to flip uh, open on the computer, and I also have to be very careful of what I share, because there's obviously a privacy policy that I have to follow with my company. So I can't be sharing. For example, if I was trying to bring out um, other similar situations that we've negotiated, because sometimes clients say that they feel like we're targeting just them, or they've brought a specific issue at hand, and I'm like, no, this is kind of how we've handled 5 or 6 cases and whatnot. Well, what are the other scenarios? If they ask me, I'm not going to pull up everybody else's file up here and show it. So there's things like that make it a little bit difficult, but definitely prepare the same way as if I was to go in person. And you have to still send in your claim, your defense, everything as if it was normal. Just the only actual portion of it online is as if you were to go in. So nothing differs from the norm, I guess.
I see a kind of a related question here about online and remote. Are claims being accepted online as filings? Like you file a statement of claim and then you can serve the other party by email or something. Or I
So
mean, I remember in I think it's in Shepherd, going in and waiting in line forever for the stamps, and then getting the copies and then going and personally serving people. How is that working?
so certain things, well, a lot of my personal our claims for him, they come actually out of Quebec. So they're very adamant about some of their rules, and they want it to be very specific. For example, I have to ink sign my defense and I have to send it in. I can't electronically sign it. So that obviously means I have to now go in person to the office. I have to sign it. I have to send it out like that. Or if I have somebody else representing me in Quebec, like we have a counterpart or a firm out there, they'll do it themselves. They'll sign it for us on our behalf. But then I eventually will have to change reps, and I will have to go through the forms. But in regards to your filing motions online, some of the stuff can be done online, not all of them. For example, the plaintiff can always file a claim online, but my defense has to go in paper. I can't do it online. And for different alternatives to serving, though, they actually, for the first time, I was actually allowed to serve somebody or actually approach them through Facebook, which we had to actually ask the court to approve, because this person was avoiding all of our calls. They'd removed themselves from their office. And the court was like, if you're able to locate them and you can prove that you've done so, then they've served and they've seen it. There's that seeing portion that allows us to confirm that they have seen this message. And they did respond, but after a while, and it's just that people will almost do anything to avoid responding to you, and I think that's the hard part. So alternatives have been coming forth like that, or you can email serve if the customer has also agreed, or like their party has like aware, like the court will allow for it, especially when the stay-at-home order was in place. They didn't want to contradict what was going on. Like, hey, for this reason, you can go out. Like, no,
As long as you were not trying to serve them on Facebook today, I think it's still
yeah.
down.
Yeah, no,
Not a good day
it would
for.
be a very one-off. And like I was, I don't recommend this. Please don't approach people on Facebook.
Now, I guess in terms of what you're up to now, I mean, big change here today. First day here at Trials College, and looking to teach. I think starting with the intro to legal class. What kind of brought you into teaching, and what can students expect, and what are you hoping to get from this experience?
Well, first, well, why I wanted to teach, um, I obviously when I was in the program, I enjoyed certain classes, certain teachers, ways of teaching, and we've all been in that position where we thought, oh man, I prefer like one teacher over the other and whatnot. And I always thought that I could do a good job if I was to, and I hope I can. But apart from that, what you can expect is I am very personable. I will be open to suggestions. So if you guys feel like there's something that you would prefer, or you would want me to teach or to include, more than happy to hear your suggestions, come forward and let me know. But I have also been in the field for a few years, and I have been doing the stuff that I'm teaching on a regular basis. So I feel like I can draw from experiences and help you guys understand from a not only a textbook theory perspective, but from a practical point of view. Um, as much as we would like to follow every single thing to the dot to the T as it is in the book, it's not like that, and it when you're doing it when you're doing it yourself, you will realize that it's a little bit different. And so for you to be kind of comfortable with that, I think it's nice to have somebody who's been on the other side and on this side. So yeah.
Yeah, so when you compare your time as a student in a paralegal program versus now getting the opportunity to be on the other side of the classroom, I think, or the virtual classroom. What can you look back from your own experiences on what did you really take away from studying the program, going through, completing a program, and then becoming licensed? I know obviously the process is a little bit differently. I mean, now it's you can write the P1 exams online. I think in a couple of weeks, a number of people will be writing it. What did you find kind of getting through that process? How did that go for you? And what can you share with students that are just starting on that journey towards becoming licensed?
um, Trust me on this one. Everything you learn is important. I don't want to say one is less than the other. But I think it's more so understanding the concepts. I think that's the bigger thing is you're not going to remember every little thing that we teach you, but understanding where it's coming from. Like intro to law is more so to explain like how laws were derived, why. Like you need to understand the why so that you can apply it yourself. And I think when it came down to getting ready for the exam, it's getting comfortable with the material, knowing where to look, because that's exactly what you're going to be doing in in a real job in the field as well. You are not going to know every aspect, every law, and I most definitely, even if I'm doing the normal day to day, there will be that one-off thing that I don't remember that I'm going to have to go search for, and being able to use your resources and reach out and ask your colleagues, and these are things that you're still going to do in your jobs and in your careers. And I think it's more so getting comfortable and understanding that that's what you have to do.
And with that, in terms of open book, like the licensing exam, open book, multiple choice exams, is there anything that either from your own experience, and I know you also certainly help students prepare for those exams, anything that you can share with students? Because I mean, most of the exams and midterms that they have here are also similar, just to kind of get them familiar
Mhm.
with that process. What in terms of approach to an exam that's open book and multiple choice versus a closed book exam or short answer questions or essay based questions, because some students are not used to open book and certainly not used to all multiple choice. What can you suggest to them to get comfortable in and excel in those kinds of exams?
Uh, yeah. Well, I'd say that again, it's knowing your resource. Like you can't open your textbook the day of and know exactly where everything is. And just like that, you have to be able to understand um, how things are divided, how things are sectioned off, so you can understand and know where to look. But that shouldn't be your first resource. Like, remember that these exams are obviously timed, and if that's the case, you can't be flipping through page by page looking for an answer for a question. My initial approach is always when you've read over, you've reviewed the material, you get comfortable with certain topics and you remember certain things. So go through the full exam, answer whatever you know off heart. That always gives you one, it gives you confidence, but you also know the gut response to some of these things. And then you can go back and kind of pace yourself and go through the other stuff. And that kind of gives you more room, and you know that you're not missing out on the opportunity to answer the questions that you know the answers to. I think that's one of the key things. I feel like if you get stuck on a question, don't sit there and waste your time when you know that you can go through and figure out the rest.
And in terms of managing time, I mean, I think that's also, as you pointed out, if you're stuck on a question, do you just say, okay, you know what, I spent 2 minutes on this question and I better just go to the next one? Or how do you kind of do all that when you're getting it is sometimes a race against the clock, because if you simply don't finish an exam, whether the licensing exam or a midterm or an exam in this program, I mean, there's no way to do really well because you're missing 10, 15 questions. I mean, even if you got
Mhm.
everything else right, I mean, it may be difficult to get the mark that you're hoping to. What can you do about if you encounter those challenging questions, or just keeping pace with everything?
I think, well, when you're looking at the exam, they kind of give you a time frame for a section, or they can tell you whatnot. And I think our exams have been set up in a way that helps you. So if you have 2 hours, be mindful of that. Keep your eye on the clock at one point or another. Don't look up and be like shocked that there's only 30 minutes left and you have half the exam left to go. After you've answered what you know, when you're going back, again, go through the questions that you've missed and reassess what you think you can answer quickly. Or if there's a section that has 2 or 3 questions that you can answer, I think focusing on that might help you than jumping from section to section when you know that you're kind of like, oh no, I don't know, and you're going to get frazzled. So I kind of group the questions even afterwards, and that helps me, as opposed to being like, okay, I'm going to come back to this administrative question and then I'm going to jump to employment and then I'm going to come back. You're again flipping through, wasting time. So that's another thing. I try to remember what questions you're looking the answer for if you have to reach to that point. And more importantly, that I can't stress this enough, don't rely on the textbook alone. Like, you have to remember to know these things on your own. Like, if you're going to flip through for each one of these answers, I feel like a lot of students, when they think open book, oh, it's going to be easier. No, it's a lot harder when you have to go through these things and go through these papers. And there's going to be too much content for you to flip through to find one specific question. So try to learn and understand and know as much as you can before walking in.
And all that, I'm glad you brought that up. Is also, they're not just simply like a word search. Like, okay, here's the question, here's the answer on page 45. What can you share about kind of being able to apply the information on that page to maybe like a fact scenario type of a question where you're given, what should this person do, or what does the rules of professional conduct say, in terms of making that leap? Because I think certainly finding the information, there's going to be questions like that, and being able to recall, but application based ones, what do you think maybe helps in terms of answering those questions?
I think we practice that every day, where in the sense that you're going to see our class lectures being set up, most of you who are in both of our classes, where we'll go through the material, but you'll have these review points where we're going to review questions that we've discussed. And these are all questions based on the topics that we've discussed. We're asking you to apply what you've learned, and and don't skip out on those opportunities. Take the leap, and even if you're wrong or even if not, you're going to get comfortable with it, and you need to understand where you're missing or what you're missing and answering those questions. And when you get comfortable with that, I think you'll understand how to apply the content you've learned in those scenario based questions. And apart from the ones that we do in class, take the chance to do those scenario based questions in the textbook. Take the chance to do the practice test and apply, and give yourself the time to read over and get comfortable with what the question is asking. And I think a lot of times in scenario based questions, when they're a big paragraph of things, everybody always jumps to the conclusion, oh, I don't have time to answer this question. Carefully assess the paragraph because usually there's about 5 or 6 questions that follow that are related to that. So take the time to actually read it thoroughly. Don't skim over it and try to jump to making a conclusion. I think a lot of people that didn't pass the exam. That's, I think I've heard, where they felt like they didn't understand the scenario very well. So that resulted in them answering a few questions wrong. So it's not a trick situation, but you have to take the time to read it.
And now another thing, we were talking about claims and small claims and even regulatory stuff. It needs strong written advocacy, and certainly the importance in a program here is to develop writing in terms of having the both the critical thinking, but certainly being able to put together either legal memos or drafting actual applications and motions and things like that. What can you suggest to students in terms of just improving their writing, whether it's generally or specifically in legal writing, whether it's for memos, whether it's for applications and statement of claim and statement of defense? What have you found from your time as a student to what you're doing today? What has helped you kind of advance your writing for those purposes?
It's completely practice. Practice makes perfect, and I cannot stress that enough. And there are times where I personally read other people's work, and it's sloppy, right? You read a claim, and it speaks to who you are when you show up in court. When you're giving something to a judge and it's misspelt or written, and there's errors all over it. It almost shows that you didn't care enough um, to do this properly, which is not the look you want to walk in with. And another thing is, somebody is paying you or valuing your expertise on this. So for you to almost be careless about it, it speaks to who you are. And I think if you all remember that, uh, it's you can demonstrate and hone in on the skill at any time. So whether it's writing an email to me or JP, don't think it's okay to just be like, yo, what's up? This is like, get into the habit of writing, hey, like, hello, this is who I am, or what it is, and lay it out as if you were doing that memo or doing an assignment. Be very thorough and when you're writing these things out, make sure that you know that you're addressing the person that you're addressing may not know what you're speaking about, and you have to write it as if they don't know anything. And I think that always helps. Don't assume anything, and when you're very clear and concise about it, it always helps.
Perfect. And I think maybe then the last piece then is oral advocacy. A lot of people and think, hey, I can write now. I've improved my writing. I passed the exam. So they don't realize as much that there's always going to be, especially with access to justice for paralegals, a greater emphasis on being in court and tribunals and speaking to matters. What can you share for students who may feel like a deer in the headlights about getting up, and whether it's on Zoom or in person, and delivering questions or a closing statement? What have you found works for you, or that you can share from your experiences with students there about getting comfortable? I know it's not going to happen just tomorrow, but in terms of better improving their oral advocacy.
Sorry about that. It's been years, and I still get nervous at certain things. For sure, it's not one of those things that you can 100%. I feel like I'm never going to be 100% comfortable. I still have the moments where I'm hesitant too, but I think it's knowing your material, being as prepared, and I always do this thing where I kind of question myself as if I was going to be questioned. So I'm like, okay, who are the parties? Like, what is it that I'm bringing here? Like, all the evidence. Be very, very, very thorough in everything that you're bringing forward, so that you're not there flipping through things and being confused and frazzled. If you know what the matter is at hand and you're very well prepared, I think that gives you a little bit more confidence. Winging it is not an option, and when the more prepared you are, the more comfortable you are. And there's obviously other things that you can do. People join a lot of groups, debate teams, and things like that to get comfortable with the idea where there isn't somebody else's matter at hand. Like, it's just a concept of getting up, comfortable, speaking, learning to be very concise, but also getting your point ahead. And if you would like, if anybody does want, there are groups that I do know that are just like, I guess, like social things that you can join, where you can debate any topic at hand. They also give you the opportunity to be surprise topics, so that you almost like have no time to prepare. So it gives you both sides, and it gives you the opportunity to be very comfortable with public speaking.
Sounds like a class activity or something that you can work in there at some point. Now, Sahana, I do mind. I mean, sorry, I do make note of the time here. Just want to make sure you're not
Yes.
late on the first day. So, if you have any final words of wisdom for any of the students or anyone else listening, paralegals and so forth, any final words of wisdom? And thanks so much for taking the time and sharing about yourself today.
I don't know if it would be words of wisdom, but for sure, I would say that time in school and learning is really fun. Enjoy it, ask questions, get involved, and don't feel shy. There is no right or wrong questions, and the more you ask, the more you know. So that would be the best. Learn as much as you can.
Okay, perfect. So thank you so much again for joining us. Wish you all the best there as you start at
Thank
Charles
you.
College with the students here, and I'm sure I'll probably see a lot more of you there in the program there. So again, anytime, anything, again, and for all the students joining in, this is something that we are planning on doing pretty much every day as soon as I can kind of recalibrate, get all the people, get them enough notice. So, as much as your actual classes tend to start from 6 to 10, make a note to kind of come at 5 o'clock. You can join in, you can ask questions like some of you got a chance to do so. And of course, they are streamed and recorded. So later on, maybe when you're teaching small claims, like, hey, I talked about that. So find ways to kind of incorporate this into our programs as well. So all the best to all of you, especially those who are starting today. And again, if you have any questions, don't hesitate to reach out. Take care, everyone.
Thank you. Bye bye.